Hello? Well, it's a great pleasure for me to be here today to introduce and chair Alan Norrie's inaugural. I've known Alan for the best part of 2 decades, since the mid-90s, when he was one of the co-founders of the Centre for Critical Realism. And since then, I've never failed to be impressed by the way in which he effortlessly wears 2 hats. On the one hand, he's a professor of law, Queen Mary, King's College London, and now the University of Warwick. On the other hand, he's a critical realist scholar and thinker, and now president of the International Association of Critical Realism. So he straddled these 2 jobs in an effortless way. And it's been an impressive performance, which I hope goes on for a very, very long time. Now, he's achieved distinction in both his day and his night job. In his diurnal job, he's author of several books, including most recently Crime, Punishment and History. No, Crime, Reason and History. And in his critical realist incarnation or hat, he's author of the prize-winning book Law and the Beautiful Soul, and this really excellent book, Dialectic and Difference. But the nice thing is not that he's had these 2 roles in life, but that he's allowed them to mutually inform and enrich each other. So that it hasn't been a question of, as might have been the fate of the beautiful soul, judging law at the bar of philosophy, and nor has it been a case of removing philosophy from his moral and legal concerns. Rather, he's allowing these concerns to inform and help to develop his philosophy. And I think what we're going to see now is an excellent example of what I'm praising, which is this capacity to allow an autonomous and very well-established discipline to be in good interaction with the philosophy, in particular the philosophy of critical realism. And I'm looking forward very much to hearing all about the scene and the crime. So, Alan, thank you.
Thanks very much, Roy, and thanks very much to everyone for coming along tonight. An inaugural is a really nice occasion, I think, because it brings lots of people together from different areas. And I see in the audience tonight students, family, friends, colleagues old and new, and in some cases, since I've returned to work, the same colleagues can both be old and new. But also former colleagues from London, including critical realists, and from King's College Law School. So it's a really nice occasion. Making a move is not always an easy thing, and it's very nice to have the opportunity to sort of crystallize a move and to sort of see people from the different areas of one's active life all together in one time and place. And Thanks to Roy for chairing. I've known Roy's work for a long time, an embarrassingly long time, from the late 70s onwards. And over the last 15 years, we've had quite a close relationship through my interest in critical realism. And asking Roy to chair tonight was really about this kind of mixing of 2 different things, a philosophical understanding, an understanding of philosophy and an understanding of law. They don't always necessarily go easily together, and sometimes I felt a bit sort of split in the way that I've gone about things, and sometimes I seem to be doing one thing and sometimes another. And I was really keen to have Roy here to, as it were, sort of symbolize the need to sort of pull the 2 together, because I'm talking primarily to a law audience, but I have a philosophical collaborator present. The only other thing I'd like to say before we start is I'm really pleased to be back in a contextual law school after a long period away. It does make a difference to be in a place where one's working with the grain of the thought of the institution. So I'm glad to be back. And what I'm going to try and do today is, in a way, I suppose, suggest one possible agenda for a contextual approach to law as we move forward. My title, The Scene and the Crime, indicates what I think is a central insight in a contextual understanding of law. Crime is my area of interest, of course. Crime is my area of interest. This is, of course, a key area of law. And as a criminal lawyer, I engage with its central legal concepts. But the concepts that we use are never just legal concepts. They're also always something else. They rely on a broader social and moral understanding of what they're about. The law is always dependent on its context, the crime upon its scene. It's the scene that animates the legal concepts and their problems, just as perhaps it animates the process of detection, as in the more usual usage of my titular phrase, the scene of the crime. But what is the scene in relation to the crime? That question can be answered, of course, in many ways. It may be the legal process, the political, the cultural, the literary milieu, the social conditions, the historical context. It's an area where 1,000 flowers may bloom. You'll be pleased to know I don't intend to pick them here tonight, but to focus instead on where I've come from and to where I'm headed. What I'm going to say this evening is tentative and in a way risky, because I focus on something that contextual lawyers have generally avoided, perhaps for good reason. What I'm going to dip my toes in is, indeed, something generally not seen as contextual at all, and that is how an understanding of ethical categories of good and evil may be required for the scene and the crime. Why? Well, I've come to this position by a process of development. In 2008, I published an essay on war guilt in Germany after World War II. This was about how we hold on to a notion of moral value in a world which systematically denies it. In part, it focused on Hannah Arendt's account of the Eichmann trial in Jerusalem and her idea that his bureaucratic approach to murder represented the banality of evil. At that point, I focused, as many do, on the idea that evil was banal. But that, of course, left open the bigger question as to what Arendt meant by evil. What did the word signify? Should we, who live in secular times, especially when we see the word evil itself banalized, made banal, and turned to bad purposes, think of the axis of evil to which we were all signed up to quite recently, many of us against our will. Should we avoid this idea? What did Arendt mean? Did she just mean it rhetorically? I don't think so, and I do think we should ask what she meant when she used the term not banality of, but evil itself. At the same time, I'd been working on a paper on the way criminal law deals with mercy killing and assisted suicide. And I was drawn to two cases from last year involving mothers who'd killed their adult, badly damaged children, Frances Ingalls and Kay Gilderdale. My focus had been on the difference between legal and moral notions of guilt. But I began to wonder what was so compelling about the case of Kay Gilderdale in particular that a jury had refused to convict her despite the fact that she was plainly guilty in law of attempted murder for which she was charged rather than murder. Looking at the case, I concluded it was because her actions could be described as, in some relevant sense, as essentially good. I'll say a bit more about this later on. So without really meaning to go there, I found myself thinking about questions of good and evil in relation to criminal law, and wondering what on earth these terms, which previously I would have avoided, meant. Perhaps I would have left it there, but for a third piece of work I was completing in this period, my book on Roy Basker's dialectical philosophy, that he's already mentioned, dialectic and difference. This work has, I think, many important ideas in it that I've been working on, and I'm not going to try and discuss them all, but one that seemed to link up with my interest in good and evil is its argument for a meta-ethics grounded in the nature of human being. Now that probably sounds a forbidding term, and one that no lawyer should be interested in. Nonetheless, it's the idea that there are things about the way that human being as a species or a natural kind is that enables us to reflect upon the ways we think about ethical questions. A meta-ethics is about the grounds of ethics, the grounds of morality or normativity, the basis for it. And it seemed to me that one could deploy such an understanding to what it means to act in terms of good and evil. Now, I'm going to do a little bit of heavy lifting at the beginning of the lecture, and then we'll get that out of the way. Let me explain a little bit about what I mean by a meta-ethics here. At the core of Roy's meta-ethics is a sense of human beings as both individuated, self-acting individuals, and as beings who need the solidarity of others if they are to survive and act in the world. Infants need and demand food, but only others can provide it for them. They need shelter and protection. They are capable of learning and language, but these will only be achieved by way of others acting with and on them, and in that way being in solidarity with them. Their agency will come from that. What is true of children is just as true of adults. We can't survive or thrive except in cooperation with others. When we are old, we require others to care for us. It's sometimes said that we come into and leave the world alone. But if that is a statement about the existential quality of being human, it is one-sided. We are born of others and we die as social animals after a lifetime of being in relation to others. This is the heavy lifting. This idea of human beings as social animals, as actors in relations with others, is the basis for an understanding of what it means to be free, but in that freedom to be connected. The core possibility of acting for ourselves lies in each of us, but it can't be realized save through the work, example, and care of others. To be free is first to have the ability to act rather than to be acted on, a certain basic ability to act, a certain spontaneity of action. This basic idea of freedom as spontaneity leads to the further idea that we would need a space in which to exercise our choosing agency. This is, too, the negative requirement that our active freedom be not interfered with, and it leads, thirdly, to the positive conception that we would need support for our agency to be enabled. Further, we are capable of grasping who we are and the context in which we act, and of acting either to maintain or change that context. So we are capable, fourthly, of a measure of autonomy with regard to our context. When we identify barriers to or blocks upon our action, we can seek, fifthly, to overcome, to free or emancipate ourselves from these. Generally, note, we must do this in solidarity with others, and we can only do so if we act in accordance with principles that reflect their needs and desires as well as our own, for otherwise they won't be in solidarity with us. Freedom in its various forms requires a complex dynamic of solidarity with others, and freedom within that solidarity with others to be ourselves. Now, this is a way of thinking about our core human nature and how we can understand certain ethical possibilities in it. What I've been describing is a set of freedoms that are, at a meta-ethical level, correlated. In this way, we move from basic ideas of freedom, such as simple human agency, so the spontaneous ability to act, and negative liberty, to more complex kinds of freedom, including positive liberty, autonomy, and emancipation. But even these more complex forms of freedom are only half the story, because we can also think of more enriched forms of freedom in which we are able, sixth, to live well, and seventh, to flourish according to what is unique in and best for us, according to what we may call our concrete universality, the sense that we are all, in some sense, able to be like this, but all different, and our concrete universality is that sense of the flourishing that would be for us, but for everyone. In the end, we can think of the meta-ethical possibility that the final step for humankind would be a world in which each of us flourished, and the condition of each of us flourishing would be that we all flourished. Roy calls this the Eudaimonistic Society, a term that's drawn from Aristotle, but which has a flavour of Marx in it as well. It is a real possibility that is imminent in human being, albeit one that remains sadly or under-actualized at this point in our species' development. That's a basic flavour of a meta-ethics. It raises many questions that I can't answer here and now. For example, how are these forms of freedom linked or in tension with each other in modern society? That's not a question I'm going to look at now. But what I want to bring out is this. At the core of human being, our core human nature, lies the possibility and necessity of acting freely and in solidarity with others as a means of promoting the possibility we should all flourish. My suggestion would be that people who act in something like this way act in ways that are good, and people who act fundamentally to deny these possibilities act in ways that are evil. But that takes us ahead of ourselves. Let's go back to our examples of good and evil. First of all, what does it mean to talk of evil? Is this just a misplaced word, so that we would be better to think in terms of acts that are bad, really bad, egregiously so? The question is implicit in Arendt's writing on the Holocaust, where, as I've said, she coined the phrase the banality of evil. Most discussion of this phrase turns on the claim of banality, but what of evil? This is what she wrote. On the screen is what she wrote to Karl Jaspers shortly after the end of the Second World War. She said, "The Nazi crimes explode the limits of law, and that's what constitutes their monstrousness. For these crimes, no punishment is severe enough. That is, their guilt, in contrast to all criminal guilt, oversteps and shatters any and all legal systems. We are not equipped to deal on a human political level with a guilt that is beyond crime. The Germans are burdened now with thousands or tens of thousands or hundreds of thousands who cannot be adequately punished within the legal system." Her letter prompted a warning from Jaspers that she was bordering on a problem. She was close to describing a guilt that goes beyond all criminal guilt, which inevitably takes on a streak of greatness, of satanic greatness. Whereas it was necessary to see these things in their total banality, in their prosaic triviality, because that's what truly characterizes them. That may have been where the idea of the banality of evil came from, though initially in her published writing, Arendt spoke of radical evil, a term she drew from Kant. Replying to Jaspers, she stuck to her guns. She said this, she said, "Still, there's a difference between a man who sets out to murder his old aunt and people who, without considering the economic usefulness of their actions, built factories to produce corpses. Individual human beings did not kill other individual human beings for human reasons, but an organized attempt was made to eradicate the concept of the human being." Note two things here. First, that what would become the banality of evil is here represented in the first place as a guilt that goes beyond all criminal guilt. And second, that at the core of her conception of evil is the idea of an organized attempt to eradicate the concept of the human being. So 2 points here. On the first, in what sense does the guilt go beyond all criminal guilt? Clearly, it was possible at Nuremberg and after, and now, to prosecute and convict people for crimes against humanity, though various questions could be asked about Nuremberg and its successor trials. The nub of her point, I think, is that what had been done surpassed what could be registered by standard criminal law categories. The Holocaust indicated a moral failure that couldn't be caught by legal concepts of the guilty mind or act. Why? An inhuman system with inhuman ends had been operated by people who had fallen so far below the level of humanity that no courtroom dialogue of guilt or innocence could engage them. A courtroom is a process of dialogue and engagement. Certainly the Nazis, or some, but not all, could be tried. They could be convicted, and so they could suffer the sanction of the court. But no legal process involving judgment and dialogue between citizens or human individuals could address the enormity of what had happened. It could sanction, but it couldn't find guilt, because guilt involved a human relation. The law was rendered in a deep moral sense void by its context, the crime by its scene. Perhaps we might say the perpetrators had proved themselves, as Nietzsche said, human, all too human. But this show of humanity, where anything goes, was beyond our limits to judge. When every man becomes a genocide, a genocidaire, as David Cesarani has put it, the legal field lacks the traction to find guilt, to condemn, to punish. The second point to note is this, that the core problem was that an organized attempt had been made to eradicate the concept of the human being. That is in part a meta-ethical statement, and I'll return to it below. Below on my text. Okay, so pause on the question of evil, and let's take a different tack. If we have to think of evil in connection with criminal law, do we also have to think of its contrary, good? I think we do. And my thoughts were prompted by the two cases that I mentioned earlier that came before the criminal courts within a week, almost a week, I think, of each other, a week or 10 days of each other in January last year. Both involved mercy killings, but they had different outcomes. In the first one, Francis Ingalls, I've put the facts up here so I can run through it more quickly. Francis Ingalls had injected her badly brain-damaged son Thomas with street heroin and killed him. It was a tragic case. Thomas had been assaulted on the street and been persuaded against his will to go to hospital in an ambulance. While in the ambulance, the door had fallen open 3 times, and on the third occasion Thomas fell out and suffered serious head injuries, whence came the brain damage. The doctors were of the view that there was some prospect of recovery, but Francis Ingalls was convinced that Thomas was in an inexpressible agony. She eventually killed him by design, and she said, with love in her heart. Now, in English criminal law, there is no defense of mercy killing, nor a lesser offense. And Francis Ingalls was convicted of murder. She had the mens rea, the guilty mind, exhibited by her intention to kill Thomas, and her good motive was irrelevant. She was sentenced to 9 years imprisonment for what the judge called her calculated and consistent course of criminal conduct. Nice piece of alliteration. On appeal, this was reduced to 5 years. The Court of Appeal was very clear that there was no defense of mercy killing and that she didn't fall within the provocation defense. She might have had a defense of diminished responsibility, but she had declined to plead this. To have claimed diminished responsibility would have focused the case on her vulnerability, and she wanted to focus on the hospital treatment of her son. Nonetheless, the eventual reduction of sentence was based on the possibility of a mitigation on account of her mental condition and the fact that this was a mercy killing. So the offence or the possibility of a defence were not available, but there was the possibility of mitigation of sentence. Second case is that of Kay Gilderdale, who killed her daughter Lynn with an injection of morphine and air into the bloodstream. Lynn had suffered from ME for 17 years, was at the time of her death 31 years old, so since the age of 14. She'd attempted to kill herself and had clearly expressed the wish to die. At her trial, Mrs. Gilderdale pled guilty to aiding and abetting a suicide, but not guilty to attempted murder. Attempted, presumably, to avoid, because she was charged, I think, with attempted murder, to avoid problems of causation. She had the mens rea for murder. The Crown Prosecution Service, the CPS, was convinced that what she had done had gone beyond assisting another to take her own life, i.e. beyond assisted suicide, and that there were acts and an intention to kill. As with the Ingalls case, they prosecuted for the more serious offence, but the jury refused to convict. The judge handed down a conditional discharge for assisted suicide and openly questioned why the CPS had decided to prosecute on attempted murder. The CPS responded that they were satisfied the evidence was there to provide a realistic prospect of conviction and that it was in the public interest to prosecute. Why did the jury in the one case convict but not in the other? In Mrs. Ingalls' case, the Court of Appeal judgment provides a sense of how the judges saw the defendant. They had some sympathy for her, seen in the reduction of the sentence, but it was also clear that they felt that she had acted, in a sense, out of her own concerns and interests rather than her son's. She had suffered from stress disorder and depression for a number of years prior to the accident to her son, and the court's judgment was that she had in part acted for herself, albeit in conditions where her responsibility should be mitigated. In Mrs. Gilderdale's case, it was different. She declined to give evidence, but the sense one gleans from the press was of a woman who had acted as a caring and loving mother, as the judge put it, who had resisted her daughter's requests for help to die, had only acted when her daughter had herself failed in a suicide attempt, and had exposed herself to the criminal law for her daughter's sake. We can only guess at what the jury thought, but the impression of Mrs. Gilderdale was a parent who had cared for her daughter for 17 years, whose marriage had been sacrificed in the process, who had acted with great reluctance and against her core feelings. She had acted, I think, in what we might call a loving identification with her daughter's position, her daughter's pain, unhappiness, and expressed wish to die, and against her own wishes and commitments in the matter. Her act was both self-sacrificing and other-oriented, to the daughter's wishes, needs, and, hard as it is to say, well-being. It was, in its solidarity with another's self-expressed sense of what was really best for her, regardless of the consequences to the mother, a fundamentally good act. Note here, as with our discussion of Arendt and the Holocaust, that two issues come out of this discussion. The first is law's problem in dealing with this case. By legal right, the defendant was guilty of either murder or its attempt. She possessed an intention to kill or cause serious harm. There was a guilty act. The CPS was perfectly entitled to prosecute. They could have declined to do so in the public interest, but that's always a problematic route because it overrides the settled view of the law that mercy killing is a crime. And it would have involved deploying a discretion that would have looked anomalous with regard to other cases. If Mrs. Ingalls is to be prosecuted, so too should Mrs. Gilderdale, and let the cards fall as they will. Accordingly, the only route available was a jury acquittal in the face of what they should have done. Now that's known to criminal lawyers as a perverse verdict, or, more euphemistically, as jury equity. It depends on your standpoint. If you disagree, it's a perverse verdict. If you agree, it's jury equity. But the point is, it goes against the law. Is the problem here simply that the law has not evolved properly to deal with a hard case, such as mercy killing? It could be seen in this way, but that would avoid noting a structural quality of the law, which is its systematic bias towards formalism in its concepts and to marginalize or finesse substantive moral issues in favor of seemingly neutral categories. I can't pursue that line of argument here, but it's one that lies at the heart of the way I have analysed criminal law over the past 20 years. Intention, for example, is a core legal concept, and it's understood in factual and psychological terms. What did the accused mean to do or foresee as virtually certain to happen is the key issue. Did a purposeful thought go through her head is the question, regardless of the moral badness or goodness in the thought. Thus, as every criminal law student learns, there is no difference for the purposes of mens rea between the contract and the mercy killer. They're both, in formal legal terms, guilty of murder if they kill. They both mean to kill. This moral substance or context of their action is irrelevant to the law's core concepts of act and intention. So I think the problem posed by the morally good act is a deeper problem than one of plain law reform, though that might cure it in the instant case, if we could agree as a society about the value of mercy killing, which, by the way, we can't. There's more to say about that, but I'm going to leave it there on that point. The problem of, I hope I've said a little bit about the problem of the law in that case. The second issue, alongside the problem of the law, is what we mean by a good act. And here I've already indicated what I think lies at its core in the case of Mrs. Gilderdale. It's an act of loving identification that was both self-sacrificing and other-oriented. To that I would add that the other orientation was to what was concretely best for the daughter in her situation according to her wishes. Now, at the core of the idea of what is best for any person, according to our discussion of meta-ethics, there lies a sense of how things can best go well for people in their lives, how they can flourish. And it might be said that this is a strange idea in relation to someone wishing to die. How can that be a way of flourishing? But it is not so strange, really, if you think about what we are speaking of here. What we are speaking of here is euthanasia, the good death. Death is a part of every life. And while from the point of view of wishing to live, we may find it hard to think of a good death, we clearly have to accept that death will happen, and however reluctant we may be, our deaths can go well or badly. Part of a truly flourishing life would be to have a good death. There's another element here too, though, which is to act in self-sacrificing solidarity with the possibility of a good death. And it's that combination of promoting a good, the well-being of another in self-sacrificing solidarity with that other that made Kay Gilderdale's act a fundamentally good one. Recognition of freedom, of flourishing, of solidarity, the three elements at the core of the meta-ethics of human nature with which I started, are all present in her acts. Now, if we can link the good to our meta-ethics in this way, what of Arendt's case of evil? Can we link that as well? Here I need to say a little more, for there has already been quite a lot that has been said about good and evil. Perhaps two roots in particular stand out as predominating in Western thought. One predates the Enlightenment and is based upon the Christian thought of St. Augustine and Thomas Aquinas. That's Kant. So one is based upon the Christian thought of St. Augustine and Thomas Aquinas, while religious in its inspiration is capable of non-religious interpretations, and that's the way that I will take it. The other is firmly located in the Enlightenment, in the philosophy of Kant, and his account of radical evil. Let's begin with him, shall we? Seeing as the PowerPoints are up, let's do it that way. Rather promisingly, Kant spoke of what he called the possibility of radical evil in the world. A key part of Kant's commitment was to rethink religious themes that relied upon God in terms of human reason. And the universal for Kant was based upon the idea of the categorical imperative, the claim one should act with regard to maxims that could be universally applied. To act for the good was indeed to act in terms of universal demands of reason, and to act in a manner that was radically evil was to act in ways that were inconsistent with the categorical imperative. And that's what this quote from Richard Bernstein's book, Radical Evil, says. Whoever incorporates the moral law into his maxim and gives it priority is morally good. Whoever fails to do this, but gives priority to other non-moral incentives, is morally evil. The problem with this approach is that its account of what is radical and evil refers to the failure to choose to think in a particular way rather than the content of what is thought or done. It is epistemic rather than ontological, about thinking rather than a broader sense of being. Choosing not to act according to the categorical imperative is radically evil even where one acts out of sympathy with another, because one has failed to follow the moral law. Paradoxically, on this reading of evil, radical evil, Kay Gilderdale would be evil if she has departed from the categorical imperative, and in breaking the law, in killing another person, she has. Now, in focusing the discussion of radical evil on the element of free thinking and choice, as I said, I think there are problems, but Kant is in line with Christian thought in the tradition of St. Augustine, because in that tradition there's also an important reference to freedom of choice and action. But there's an important element in the Augustinian and Aquinas tradition that is different. For Augustine, and that is an ontological idea of what is substantively good and substantively evil. Evil in the Augustinian tradition is to be understood as a negation or privation of being. For Augustine, all being is good, there is a hierarchy of beings, and evil is not being but a lack of being. So that's the quote from Augustine on the screen there. And evil is eradicated not by the removal of some natural substance which had accrued to the original, or by the removal of any part of it, but by the healing and restoration of the original which had been corrupted and debased. And Aquinas says something similar. No being is said to be evil considered as being, but only insofar as it lacks being. Now, that provides a sense of evil related to being. That is an evil that is in the thing itself, an absence of the good. Such an approach has its problems, but it seems in a way more fruitful than Kant's epistemological take, choosing to think wrongly. Recently, Terry Eagleton has used this tradition in a modern way, in a modern non-religious way, to think of evil as a fundamental absence in the way in which a person might treat others and how she might be in herself. As for others, evil is in love with the annihilation of the possibility of life. There's a quote from Terry Eagleton there. There's a diabolical delight to be reaped from the notion of absolute destruction. Flaws, loose ends, and rough approximations are what evil cannot endure. Goodness, by contrast, is in love with the dappled, unfinished nature of things. Such evil, Eagleton goes on to write, has a correlative lack in the evildoer. To wreak havoc on being is to express the inner lack that psychoanalysis describes as the death drive. And there's another quote there that talks about this. It's about a negation of being in the world, which is also about the lack, expressing the lack that is within oneself and that one turns out on to the world. These ideas, I think, are interesting and helpful because they focus on the notion of the negation of being, and they focus us, but they also retain a focus on a sense of what it is in human beings to be evil. It's what human beings do, but it's also about the way they relate to what they do. There's two dimensions to it. What I want to do is I want to think about that, and think about it in terms of that meta-ethics of freedom, flourishing, and solidarity that I spoke of already in relation to the good. And here I'm going to go back to Hannah Arendt again, because when you look at what she has to say, this is really, I think, what she's talking about. So there's a quote from Hannah Arendt. She's often thought as following in the line of Kant, for she had, as I said, she adopted the notion of radical evil in her discussion of the Nazis and the Holocaust, although she then changed it to the banality of evil. And she linked it to the thought process and motivations of the evildoers. So in this quote here, she says that it's in the final stages of totalitarianism, an absolute evil appears. Absolute, the line in brackets, absolute because it can no longer be deduced from humanly comprehensible motives. Right, so it's about thinking in a particular way. Later, without seeming to wish to change her analysis, she dubbed this absence of humanly comprehensible motives the banality of evil, because the Holocaust, in her view, was carried out by ordinary people in a mundane, unthinking way. So there is that sense of thinking and failing to think in Arendt's approach to the problem of evil. But there's also something else going on there, which is to do with the nature of what is done. For the victims, the evil of the Holocaust was seen in the denial of their humanity, both their freedom and their solidarity with others. Here's a quote where she talks about the abolition of people's legal freedoms. She says, "The aim of an arbitrary system is to destroy the civil rights of the whole population, who ultimately become just as outlawed in their own country as the stateless and homeless. The destruction of man's rights, the killing of the juridical person in him, is a prerequisite for dominating him entirely. And after you abolish the human rights, you go right down to abolishing the possibility of freedom of action at all. After the annihilation of the juridical person, the destruction of individuality is almost always successful. For to destroy individuality is to destroy spontaneity, man's power to begin something new out of his own resources. That's the basic notion of freedom of choice, freedom to choose, that I started out on the meta-ethics with. At the same time as there's a denial of the most basic kind of freedom of choice, there's a denial of the very possibility of solidarity with another. Here's a quote that just puts the point very well. Who could solve, she says, the moral dilemma of the Greek mother who was allowed by the Nazis to choose which of her 3 children should be killed? Faced with such a choice, what possible action of human solidarity was available to the mother? Solidarity, the very possibility of solidarity in the victims was removed in this way. And not only that, and this is where the banality of evil comes in as an issue of solidarity, not only that, there was an annihilation of the moral bond between the perpetrators and their victims. There's a difference, Arendt claims, between the person who murders for humanly recognizable motives and the person who does so for no apparent human motives at all. We've already seen how Arendt wrote of the difference between a man who sets out to murder his old aunt and people who, without considering the economic usefulness of their actions at all, built factories to produce corpses. One can talk of a form of wickedness of the person who acts for bad motives. And Arendt saw that many Nazis acted for bad motives, out of a deep hatred and resentment against those who had done better than themselves. But such resentment, she adds, which never died out entirely in the camps, strikes us finally as a last remnant of humanly understandable feeling. It's one thing to hate people. There's a kind of negative solidarity in hate. Once you move beyond even hating people to a complete indifference to them, then you really have moved beyond. There's a negative solidarity in hate. There's no solidarity at all in the kind of actions that the Nazis perpetrated. Okay, let me see how these PowerPoints are going. They've gone. Okay. I must be getting to the end. Now, at this point, I do wish to move into some concluding thoughts. I say that rather than conclusion because I don't have the neat finish to apply to what I've said thus far to bring the loose ends together in a unified whole. What I did in the above was to follow a line of thought that was in some sense instinctual. I had been interested in Arendt. I had been struck by the moral problems of euthanasia, but I had not imagined I would end up thinking about good and evil and putting these together with a meta-ethics around questions of freedom and solidarity. Yet if there is an excitement in academic life, isn't this what it is? The possibility of discovery of a new route through the thickets of thought. Is it just the physicists or the mathematicians who can discover something new? A new way of thinking about one's subject, or at least one's own position in one's subject? I don't think so. We academic lawyers are caught between the devil of legal practice and the deep blue sea of social theory and moral philosophy, in that intermediate position which seems to offer as much in the way of frustration as satisfaction. But we too can have our rewards. We too can push our thought forward in a way that develops our understanding of law, law in relation to thinking, law in relation to the world. What are the consequences of this paper? First, it has been to push forward an understanding of criminal law as a would-be technical and formalistic discourse of mens rea, actus reus, and the defences, in the light of the problems that morally substantive categories such as good and evil throw up. There's a kind of silence in the law before issues such as euthanasia or crimes against humanity, in part because these are the extremes of human conduct, and in part because law is not well equipped to deal with actions that wear their moral heart, for good or ill, on their sleeves. In terms of the dialectic of freedom and solidarity, law is most comfortable with the lesser forms of freedom, which, important in themselves, are nonetheless limited in their scope. I have in mind the particular kind of juridical freedom Arendt spoke of around simple notions of the ability to act, spontaneity, or of negative liberty, the freedom to act unhindered. When it comes to the broadest notions of freedom, of human flourishing and solidarity, and the Eudaimonistic Society, this is not ground on which law is comfortable. When it comes to systematic attempts to deny the very possibility of legal subjectivity or solidarity, law again struggles. These are the terrains of good and evil, and I think it helps to stretch out the canvas of human freedom in order to see where on it we paint the colours and forms of the law. At the same time, I acknowledge my hesitancy to pursue such solid categories as those of good and evil, if there is a risk that they themselves become a means not of doing rational work, but of hijacking it. Nonetheless, perhaps the best way of avoiding that happening is to be clear on the meaning, the nature, and the limits of such concepts, so that we can be clear when they are being stretched further than they should be. I'm consoled that I'm not alone in pursuing this kind of thinking. It's notable that thinkers such as Terry Eagleton and Peter Jews, thinkers of the left, have also taken up the issues in recent times. Besides, if the genocides of the past and present teach us things, surely one thing that they should teach us is to name moral phenomena accurately. And I've never felt that Arendt was wrong to designate the Holocaust as evil. To return to law, it is, as I say, most happy with simple notions of agency and negative liberty. But if we can identify such notions as a small part of the broader canvas, which includes autonomy, emancipation, and flourishing, we can vindicate the need to provide a radical critique of the legal space at the same time as we identify the value that is in legal form. Of course, freedom as agency and negative liberty is compatible with, indeed it licenses, the kind of laissez-faire liberalism that has done so much damage to our social institutions nationally and internationally over the years. So to note the moral significance of such ideas is to note also the impossibility of treating them by themselves. Negative liberty left to couple with the market can produce terrible effects in the name of freedom. But that to me does not mean that we should dismiss such an idea. It may have real value when the police come knocking at 5 a.m. More generally, what we need to do is always think of such liberty alongside the deeper, more substantive forms of freedom of which it is a part, so that we can ask how the simpler forms can be married with the more complex forms to produce societies in which well-being and flourishing can occur. Of course, that's by no means a simple matter. It requires contextual socio-legal analyses of cause and effect and of the value of agency and intervention. But if we need to embed our understanding of moral agency in contextual analyses of society, we surely equally need to have a clear understanding as contextual lawyers of the moral values that are at stake in any given social situation. Overall, the aim should not be to discard our notions of freedom, the legacy of the Enlightenment, but to pursue and deepen them alongside a critical understanding of how they may be used and abused. The process of thinking in this paper has gone two ways. On the one hand, it has been from the problems generated by concrete legal problems to an underlying moral ground, the meta-ethics described above. It has sought to locate those problems on a broader theoretical canvas. On the other hand, it has anchored the meta-ethics in real-life situations and therefore revealed something of its necessity. The meta-ethics fills a space and is validated in the process. When I've presented talks on meta-ethics previously, I think it sometimes comes across a bit like a list. By linking these to a concrete analysis of legal problems, we can see, I think, their grounded intrinsic importance. The canvas has been stretched. Let's see where else it might take us. At the same time, I'm aware that this paper will probably satisfy few. It says too little about the law for lawyers, it says too little about the concepts of freedom for philosophers, and it says too much about these same things for social contextualists. For me, however, it identifies the terrain where I want to work, between legal problems, ethical forms, and social contexts. I hope it provides one way of pushing forward an open contextual agenda for legal studies, and that it perhaps rings some bells with some of you present tonight. I feel sure that if it doesn't, you will at some point let me know.
Thank you very much, Alan, for that inspiring talk. Alan, you're willing to take questions now
Sure.
for 10 or 15 minutes.
We'll take easy questions.
Easy questions. So who would like to start? Murphy.
I can start off with a very short one, anyhow. I have problems about thinking of Mrs. Gilbert. I agree with Roy's comment. It was inspiring, etc. I found the whole lecture really embracing. But just this particular point, Mrs. Kate Gilderdow? Yeah. I have problems thinking of what she did as an act of self-sacrifice. I mean, at the level of what critical realists would call the actual, it is certainly self-sacrifice because there are unpleasant consequences of it in terms of going to criminal court and so on, and being charged. But surely, on a critical realist sort of premises, it's also an act of self-realization. I mean, if she did not do what she did, she wouldn't be being true to herself.
I said easy questions, Mervyn. And that's a really interesting point, and I'd like to think about it. I mean, at some point, it's plainly the case that it is self-sacrificing. You know, she's a parent who loves her daughter, who I think the fact that she risks legal sanction is probably the lesser part of the self-sacrifice. It is the fact that she is prepared to assist her daughter in dying, to bring her daughter to death, against her wishes as a loving parent. So I think at some level you have to be able to say that there is self-sacrifice in that. At the same time, I can see what you're saying about, in a sense, when you look at when how can one put oneself in the place of someone like that? And I find these things quite hard to talk about, because one hasn't been there. But one might want to say that at some level there is a sense in which that was her life. She lived her life, and the best way that she could live her life was to do the right moral things within it. So I wouldn't want to deny that final point that you're making, but at the same time, I think in a world where people have to act, and where, as it were, what we become emerges out of what we are now, and what we are looking back on what we are now. You know, if you were to say to her, as she did it, Mrs. Gilderdale, you know, you're really fulfilling yourself doing this, I don't think she would have reacted that way. So there's some sense of both. There's some sense in which you're right, but some sense in which I'm right too.
Probably turns on different conceptions of the self.
Yeah.
But yeah, sorry, I don't know most people's names. The guy said, did you have your hand
I
raised?
did vaguely, but someone else.
There's a young lady down here.
Oh, sorry, yeah. Alan, you're probably better at it. Yes,
Shall I
the
take-
lady.
yeah.
Yeah.
Right. I was wondering whether, your criteria for the meta-ethics kind of reminded me, maybe wrongly, of Fuller and Finney.
Okay.
And I was thinking how those came into being. Because there are specific criteria out of an infinite number of things that could have gone to list.
Okay. But why that list? Okay. Well, it's based upon an understanding of what it means for us to be human beings. Now, what it means for us to be human beings comes both in terms of what we are as human beings, and also what we've become in through a process of historical evolution. So there would be times in the history of the human being where you couldn't have included all those different kinds of understandings of freedom within it. Different historical periods generate different conceptions of freedom. Where we've got to in this incompleteness that is modern human being is a position in which we're able to reconstruct the experience of human freedom as it pertains to human beings in their history in terms of a logic that can start with the most basic forms of freedom and can work towards the most developed forms of freedom. So where it comes from is us, is ultimately us. These are possibilities that are within us to be free in these different ways. That's how I would answer it. Peter.
Okay, I'm nervous about being and all of that, but if we go with your meta-ethics, which in principle I can understand where you're going. Well, what does it tell us about law exactly? Because in your own account, it seems only to shine a sharper light, if you like, to clarify the limitations of law in relation to the project of your meta-ethics. The law is precisely what can't in the end do good. You have to leave that to the jury, 12 people, to do what the law says they should do, if you want to do good on your account. And then in relation to truly radical evil, I think it's interesting the Arendt's account and realise how sceptical about Nuremberg it is. That really, if you want to deal with radical evil, you need arms. because in a courtroom you can't really address yourself to the defendants aren't really appropriate subjects for a courtroom trial. They're a bit more appropriate for Churchill's recommended treatment for the Nazi leadership. And so you need armies and violence and politics to deal with truly radical people. So if you're dealing with these goods and evils at that level, law is exactly what can't. Law is just a practice that is about rights and violations of rights. It's unable to speak. Is that the end where you're headed, or is there some?
This is, as I said, what I've done is I've pulled together different things I've been thinking about, and what I've tried to do is to make sense of a particular issue within law in terms of this meta-ethics. So, as regards, what I tried to do in the last few comments that I made was to sort of step back a little bit from the particularities of mercy killing and the Holocaust to some more general thoughts about law, because the legal world, the world mercifully, is not just made up of mercy killings and Holocausts. So the way in which law reacts to that is a specific, as it were, application or engagement with the meta-ethics for human beings. Then how do we understand the particular ways, generally, so that sounds a bit, the general ways in which law is shaped under particular social and historical arrangements? And so, for example, if modern law is, to a large extent, as it were, Kantian in its inspiration, i.e. it's based on notions of responsible individuals all engaging with each other, then that gives you an overall shape of modern law based upon individual freedom, the kinds of basic forms of individual freedom that I described at the lower points on the meta-ethics. So I want to talk about what's really possible, and the way in which modernity sort of takes what's really possible and deals with it in a particular kind of way. And what I tried to talk about in Dialectic Indifference was sort of frameworks that talk about the ideal and the actual in relation to the real. But that's really, I can't say much more than that here and now. Not because I haven't said more about it, but because it would be another lecture.
Yeah, but surely one thing also is that your perspective is that the law can be changed. What is the law? Is itself a social and historical product. And so part of the project is to improve the law, to enhance, refine it, gradually. And this is surely, what will eventually must happen.
It's about improving the law, but also being aware of its nature and its limits.
Yes. Yeah.
And it's that sort of double thing, I think, that's really significant.
Yes, up there. Hi.
I too sort of wondered about that quote from Arendt. Can you hear me okay?
I can hear you, yeah.
No, could you speak up a bit? It's a bit hard.
One person can't hear. Some of us can't hear you, Dan. Can you come?
About the Holocaust breaking the limits of the law.
Yeah.
I mean, it's something that Arendt wrote just after the war. And I wonder, really following through on your question, Brian, that once the law changes so that crimes against humanity, law of genocide are developed, then events like the Holocaust can be grasped by law in law's own way. And the way in which law grasps anything is to abstract from the situation. I mean, there's nothing, it always abstracts from a total situation to bring out, a question like, is the defendant guilty or not guilty? So it's a very kind of limited view. And it seems to me that Arendt's position is not really, it's difficult to capture it, or for us at least, whatever Arendt's position, that with the notion that the Holocaust is beyond the limits of the law, because the law can address anything if you change it, and it can address the Holocaust. Of course, it's not a total response. It doesn't deal with the big issues, but it can respond to the Holocaust in a legal way. So I'm slightly wary of this notion that there's some kind of event that's outside the limits of the law.
Okay, yeah. So I don't know if everyone heard that, but it's the notion that the law addresses things in its own way, and there's a worry about things being outside the law.
Yes.
Yeah. So, well, yes. I mean, that in a way is kind of, that's the point we agree on. It's that the law addresses things in its own way, and that's the, and it's a question of, well, how adequate is its own way? Of course, the law can arraign people. It can pull them into courts. It can try them. It can sanction them. So, in a sense, you know, the thing does happen. The trial does happen. The crime is judged through the law. But it's what's lacking in these kind of situations at the same time that I think is remained with Arendt throughout her life. And okay, so she died before we had an international criminal court. But when she wrote about Eichmann in the 1960s, she was expressing the same kinds of worries. And there were worries about, the thing about the Nazis was, how did you deal with them? You couldn't say that they were, I mean, there are kinds of people who come before courts. We often call them psychopaths or the mentally ill, and we think we can't engage with you in this court process, okay? Because they don't engage in a human. They can't engage back in a human way with us, and so the law gives them various defences and so on. The thing about the Nazis, the thing about genocidal people, is that they're not like that, and yet there is something in them that is also seriously lacking. There's some kind of moral core or moral compass that is absent. And I think that's the problem of every man, as David Cesarani's phrase, every man is genocidaire. You know, when we have a whole people that has acted in this way, they come into the court, or their representatives come into the court, and we look at them and we try and engage with them. What kind of people are these? And you know, the historic, sort of the empirical manifestation of that was the Auschwitz trials in Germany in the 1960s, which Arendt also went along to, where you know she observed these former camp guards and so on, and just was unable to do anything other than describe their kind of pathetic lack of moral being. You know, they didn't engage with the courtroom couldn't engage with them. So it has a practical manifestation as well as, I think, an underlying moral problem. Thanks for the question.
Yeah. The
I
lady
find
in the front.
The talk really, really interesting. I have two related questions following on from what you've been saying. The first was that I'm interested in this idea of evil being a lack, and I wondered whether thinking of it this way runs the risk of producing a situation where all is either good or evil, and whether that in the criminal law it seems less inherently problematic, but in tort, for example, I wonder how to think about that. My related question is that by establishing an ethical framework to contextualize law, is the idea that decisions would begin to be formed with respect to principles outside law itself, that the ethical framework would provide a ground for doing law as well as analyzing how law is formed. And if that's so, if we're all consensual on the ethical framework, that's one thing, but would this run the risk of introducing a politicization into the law where we disagree about the ethical framework?
Thanks, Mary. Yeah. On the thing about good and evil, that's my worry about. That's the thing that worried me when I was doing the talk. When I was writing the talk, I was worried about sort of having these kind of concepts that would overflow all boundaries and would just kind of take over. And so what I really wanted to do was to, I think what focusing on the two examples I focused on allows you to think about the right kinds of examples, if you like, rather than sort of allowing sort of good and evil to sort of be everywhere. The right kind of examples in the sense that the euthanasia example shows you people acting in solidarity with the well-being and in self-sacrificing solidarity with well-being of others. So it's something that doesn't come mercifully. It's something that doesn't come to all of us, and that's all to the good. Similarly, at the bottom of the pile, as it were, there's the evil act, which is this total negation of the very possibility of spontaneity and solidarity. So I was then thinking, this is going to, what about this, what about that? I could see all sorts of other things coming in to play as a result of that, which I don't have answers to, but I think that kind of meta-ethics does give you a kind of way of allocating and achieving differences in the way we think about things. On the point about if we load law up with more, then do we politicize law? I think that probably is the case. I think that would be one of the things that would happen. That's one of the reasons why I'm worried about the notion of a perfect law. I'm not sure. Law is a social and historical phenomenon that is related to and grounded in ethical possibilities for human beings. But that doesn't mean to say that law can, as it were, be filled up like a vessel that has all the ethical possibilities for human beings. I think at some point we move beyond law, and if we try to sort of make law something different from what it is, then problems can flow from that. I think we need to get a drink.
Okay. So I'm sure you'll be able to find another forum to ask Alan further questions, but we could have gone on for several hours, I think.
Not without a drink.
We could have. But thank you very much again, Alan, and it's been a pleasure to be here, and I've really enjoyed it, and I think this is an inspiring discussion and very good questions as well. So thanks.